There we go. Good afternoon, everyone, and welcome to LAWASIA's antitrust session. We've been doing a series of webinars during the pandemic, covering numerous areas of law, and today, as you would know, is slated for the antitrust session. So welcome everyone to the session. My name is Anand. I'm a practicing lawyer from Kuala Lumpur, Malaysia, and I'll be moderating your session today. And I would like to say thank you to everyone from wherever you're dialing in. We have a good coverage of delegates for this session. I think from the list that I saw, I think people are dialing in from about 40 to 50 countries from all over the world. So what I'm going to do now is I'm going to introduce the panelists to you. And after that, shortly after that, we will start the session. And that may also give a few extra minutes for some people to dial in. So I understand there's an indication of housekeeping announcements. So is that something, Magda and Shanna, that you wish to address, or has that been sent into the chat box?
We're doing that in the chat box. So you just carry on with your announcements, please. Okay.
So the housekeeping rules have been sent into the chat box. And what I would do is I would invite participants to send in their questions at any point in time, but to put them into the Q&A section of the webinar. And we will address the questions as we go, most likely towards the end. But instead of everyone crowding the Q&A with questions at the end, if you do have any questions that come up along the way, please do key them in. And so as we get to the end, we'll have a better idea of how much time we have to manage questions. So try not to keep all your questions till the end, try to key them in as you go. And we'll be checking from time to time what in terms of the numbers of questions, and that'll help us to manage time. So with that, I'm going to introduce the panelists. So the first panelist I'd like to introduce is Ms. Leah Alizia. She's a partner in Makarim & Taira. That's an Indonesian law firm. She's a partner in the corporate commercial litigation and dispute resolution departments of the firm. And she provides advice on Indonesian law, and she has approximately 20 years of experience. Next would be Dr. Corinne Chew. Corinne joins us from the Competition Law and Regulatory Practice of Drew & Napier, Singapore. She's the Deputy Director in the practice. And she's widely regarded as an expert in competition law in Singapore and well recognized, and has a very large coverage in terms of a practice area, in terms of the subspecialties of competition law. Also joining us would be Mr. Andrew or Andy Matthews from New Zealand, who has his own firm, Matthews Law. And he has been in practice for approximately 30 years. He was a partner in Minton Ellison before he set up his own practice some 7 or 8 years ago. And he's also, in that time, worked in the London competition team of Allen & Overy, and is well recognized as one of the leading practitioners in competition law in New Zealand. Also joining us from Australia is a competition economist, Dr. Ian Mcewen, who is the managing partner of Competition Consulting Asia. Ian is a visiting professor in the law faculty at the Australian National University. He has a first-class honors degree in law from ANU and also a PhD in economics from ANU. So he's widely regarded as one of the leading competition economists in this region. He was formerly attached to the Competition Commission of Singapore for many years and played an instrumental role in the early years of the CCS, as it was then known. And he's one of the luminaries of competition law, and he's, as I mentioned, and he's taught with some of the leading names in competition law globally, including Ginsberg, Wright, Kovacic, and others. Next up, we have Dr. Nguyen An Tuan from Vietnam. He's a partner in L&T Partners. He's a partner in charge of the corporate practice, and he acts for MNCs and pharmaceuticals, FMCGs, and other matters relating to all matters of corporate law, commercial law, as well as competition law. We also have joining us Ms. Takako Onoki, who is a counsel with White & Case in Japan. And she has been in practice for a number of years, covering competition law work, investigations into cartels, unilateral conduct, and all manner of things handled by the JFTC in respect of which clients may require Japanese counsel. So that is our list of panelists, and the topic we have today is competition law in the age of COVID. So what does that mean? As you know, competition law generally is there to foster competition and not collusion between competitors. But how do the exigencies and unusual characteristics, extraordinary, I should say, that arise in a pandemic affect the rules of competition law? So now this may differ from jurisdiction to jurisdiction. Some jurisdictions have issued fairly extensive guidance for enterprises and undertakings in terms of possible collaborations. And some jurisdictions have not done very much by comparison. So, for example, Malaysia has not issued any specific guidance for collaboration between competitors in a pandemic. But some other jurisdictions may have. I think we've seen some fairly extensive guidance issued in Europe, as well as in some of the countries in Europe. And perhaps we could address some of those a little later. So that's just to set the scene. And now what I'd like to do is I'd like to invite our competition economist on the panel, Dr. Ian Mcewen, to give us his thoughts and some opening words, perhaps an overview of the landscape before we move on to the panelists. So Ian, if you're ready, over to you.
Thank you, Anand. Okay, so how do I get the slides up? Share screen again? No? Okay, can everyone see that? Hello?
Yes, they are.
Okay, Anand asked me to do a bit of an overview. I'm also a lawyer as well as an economist. So my area really is law and economics, and which is almost a sub-discipline of both law and in economics. And what Anand asked me to do is just to look at what the issues were and how some countries had resolved some of the issues involved in with COVID. And that's what I want to do. So, but let's get back to basics. COVID-19 adversely affects on both the health and the economy in countries. Now, competition law is essentially focuses on economic outcomes, not health. So my comments will be related to that primarily. Now, what's the problem with collusion or dominant firm conduct or whatever? The result is that conduct leads to higher prices, reduced quality of service or product, and less innovation, which the last one I think is probably one of the most important issues for, particularly for Asian countries. And so regulators around the region have to be not only concerned with ultimate price to consumers, but to the longer term innovation, research and development that is so important to economic development and growth. Now, the main issue that most lawyers will face in the short term, I think, from COVID is how the regulator will respond rather than the laws and how the black letter laws apply to specific fact situations. And that's what I really want to focus on. What should a regulator do about it? Because that then provides sort of an in for lawyers to be able to discuss and argue with competition regulators about what's good in the short term, given the economic problems that COVID has caused. Now, what they could do is not enforce it all, because it might add to unemployment and bankruptcies, but this is highly unlikely. The second thing that a regulator may do is to just reduce the penalties from infringements of the competition law. For example, recently the Competition Commission of India ordered 9 bidders to cease and desist from indulging in collusion, but they didn't impose a penalty in recognition of of COVID. That's also true of a recent case in Malaysia, which Anand and I were involved in, involving insurance. The penalties imposed by the Malaysian Competition Commission were reduced because of COVID. the third set of sort of problems, which I'm really going to mainly focus on, is a regulator not actually enforcing the law, as opposed to not penalising conduct, and that might occur where enforcement results in fewer firms. That's, you know, there's so many firms that are going out of business, particularly in the travel industry, that enforcing competition laws may actually speed up the demise of some companies, and regulators should have to take that into account. Another possibility is where the conduct itself is not adverse or as adverse as it is during normal circumstances. And I'll talk a little bit about both of those in a moment. Now, Anand just mentioned that many regulators haven't produced extra guidelines dealing with COVID, but where they have, they tend to be generally fairly vague. And I've got a couple of quotes from one from the US Department of Justice, Federal Trade Commission, which said that agencies that have, I'm missing part of the presentation on my slide, so I just have to go to a hard copy. The agency explained most joint purchasing arrangements among healthcare providers, such as those designed to increase the efficiency of procurement and reduce transaction costs, do not raise antitrust concerns. Now, I would think that most regulators around Asia would certainly take that sort of factor into account. The second is where there's only short-term adverse effects, and the ACCC says that a competitive economy will be vital to Australia's future so much as if possible. The ACCC wants to ensure any change to the competitive landscape now are temporary, and the ACCC is ready to play its role. Implied in that is the fact that they may allow certain conduct to go ahead, but they want to ensure that it only persists for a short period of time while the full impact of COVID is still with us. Okay, well, I'm going to put this, my economic hat on this, and sort of look at this really from two different sorts of issues. The first is where the benefits, or the net benefits, social or economic, of non-enforcement are greater than the anti-competitive detriment. And that's where, say, the economic benefits from a new product or collusion to produce a new drug, for example, are greater than the short-term increase in price or quality or whatever in the short term. I'll talk about that a little bit more in a minute. Another one is where enforcement actually might reduce the number of firms, and I'll talk about that in more detail as well. The two examples I want to use of net benefits is firstly the net economic benefit that is used in Singapore, where net economic benefits that outweigh any detriment are permitted. And then the slide says what the test is. In Australia, on the other hand, there is not only the net economic benefit, but the net public benefit, which is a much broader test than economic by itself. I was involved in the drafting of the Singapore Act with the Ministry of Trade and Industry, and I argued strongly against Singapore adopting a public benefit test because it led to a competition regulator with little expertise in matters outside the economics of competition, making judgments which really should be up to Parliament. Anyway, Singapore adopted that, and I think it's a much better test than is the case in Australia. But in Australia, authorisations are allowed, which if they are sought in advance through a public process, can be authorised. Conduct that would otherwise breach the Act can be authorised, and the different sorts of things that can be authorised are mentioned in the slide. There's also a separate procedure called exclusive dealing, which again where conduct is notified, and that this can be, which is not as formal as the authorisation process, but it can be notified for exclusive dealing, resale price maintenance, or small business collusion, which can be important in a COVID situation, where perhaps lots of small firms want to collaborate simply to survive. I think of Singapore and the food courts there, for example, as one simple example. Okay, just look at where some examples of those 2 points I was making, where enforcement reduces the number of firms. Now, in most jurisdictions, the failing firm defence is used in the case of mergers. For example, if we have 3 firms, one of them's going out of business, and so the firm going out of business merges with one of the other firms, you end up with 2 firms. But you'll end up with 2 firms anyway, even if a merger isn't allowed. I know there's lots of problems with regulators accepting whether or not the outcome is likely to be the demise of a firm, but just assume that it is for the moment. So in that case, a distressed firm, and there'll be a lot more distressed firms under COVID in the next 6 or more months, that the regulator may be more willing to accept this failing firm defence given these economic conditions. I haven't heard of any examples of that, but it's possible. And why is it important? It's because that this failing firm defence may apply to different sorts of conduct, even though there aren't any at the moment. Another example is where there are efficiencies arising from the conduct. And the example here is where 2 pharmaceutical companies work together instead of competing to develop a COVID-19 drug. It's okay if a cooperation results in benefits, and that's not only the economic benefits, also the efficiency with which the process occurs. It may mean that the research and development achieves positive results quicker at a lower cost, all of which is relevant and should be considered by a competition regulator. Another type of conduct which may be relevant is a dominant firm's conduct. You know, in Europe, it's called objective justification. But again, the competition acts around Asia vary a bit, but in some countries, it is possible to excuse dominant firm misuse of power through some sort of efficiency test. And the example I've got there is where a company refused to supply intellectual property rights to a company who has a poor record of protecting rights. Now, that's fairly well established in a number of jurisdictions, that principle, but it may be more applicable during COVID, where the firm with the intellectual properties is very concerned that a firm who doesn't do it or doesn't protect licensed intellectual property behaves badly because of the opportunistic nature of the pandemic, or the likelihood of the pandemic. So the final thing I've just mentioned is just to basically say that it's possible that the failing firm defence does apply to other types of conduct. And it's not hard to think of anything. Almost every type of conduct will do that. I haven't got examples because there is no sort of precedent as far as I'm aware of this sort of conduct being covered. As I said, it's covered under the authorisation provisions in Australia and I assume in New Zealand. But it could be that, for example, markets, there is some sort of market or customer allocation agreement between competitors which ensures the continuity of supply at a time of declining demand. So, I mean, I think lawyers need to really be very serious about looking for good reasons why the economy is going to be better, because at the end of the day, competition law is not to earn lawyers large incomes. They're there really to improve the economy. I say that at many law conferences, but I'm mostly ignored when I make that comment. But that's a reality. Lots of these sorts of conduct may be justified in the short term as long as they don't continue for a long period of time, simply because the benefits are there, and that some firms will go out of business in the longer term if this isn't allowed. So, I mean, you really have to look, when you're advising clients at this particular time, you should be looking at the wider economic consequence, not just the limited words in the Act. And that's my introduction anyway. So I'm looking forward to the other panelists commenting on that, if possible.
So I'll take that as my cue to introduce Takako, and Takako is up next. But just before that, if I could just quickly add to Ian's observations. So in Europe, as I said, lots of guidance has been issued by competition authorities. And what the authorities are focusing on are those types of conduct which are beneficial. So for example, if when it comes to the supply of essential goods and services, especially essential goods, if competitors do engage in some collaboration to ensure that there is a continuity of supplies throughout the country, there's an even distribution of supplies throughout the country, that would be permissible. So exchange of information between supermarkets to make sure that they don't run out of certain goods in the north of the country while it's oversupplied in the south of the country, for example. That sort of thing is permissible. And in some countries like in the UK, they've given some specific guidance to say these things, when it comes to stocks and supplies, to make sure that people can make it through lockdown, those things would generally be permissible. They've also given some guidance on things which are not permissible. So for example, discussing future pricing strategies, future business strategies, future models post-COVID, those things would not be acceptable because obviously the pandemic, you're anticipating that the pandemic is over. And certainly one of the things that the authorities are quite concerned about would be price gouging or increasing prices of goods which are required. So for example, if somebody attempted to profiteer on, I don't know, toilet paper, depending on the country, or hand sanitizer or face masks, those are things that competition authorities would certainly clamp down on. So guidance has been issued in a number of jurisdictions, but in some countries, it's just not been given. So in Malaysia, for example, there's no specific information that's been issued by MyCC. There is a joint statement that was issued by the AEGC, or Asian Group on Competition, but it's a very brief statement, and it's a rather puzzling one because they seem to, it's almost as if they seem to think only bad things will happen. There isn't any discussion of efficiencies. There isn't any contemplation of people having to cooperate to ensure a continuity of supply across a country, things like that. It's just saying that competition law will continue to apply and we'll look out for any bad behavior, that sort of thing. So I don't think the ASEAN statement goes far enough. So that's just to add a little bit to the flavor and the introduction of the topic. And with that, I take pleasure in introducing or reintroducing, I've already read out a synopsis of the CV, Ms. Takako Onoki from Japan. And Takako, over to you.
Thank you very much. I'm sharing my slides right now. Can you see my screen, my slides? Okay, then my name is Takako Onoki. I'm a Japanese qualified lawyer working at White & Case Tokyo. Today, I want to cover competition law in the age of COVID-19 from Japanese lawyer's perspective. So these are questions that I will try to respond as much as possible. So from my point, I will explain about these 4 topics. First, basic rules for information exchange between and among competitors. So the first question that we shall be covering is it acceptable for competitors to exchange information during a pandemic? And if so, to what extent? Under the Japanese antitrust law, information exchange between our competitors itself is not violation of the Anti-Monopoly Act. However, such information exchange can lead or can be evidence of an agreement with competitors. So for example, information exchange with competitors can be evidence for cartel agreement. So, and also an agreement with competitors would violate the AMA when it substantially restricts competition in a relevant market. So which is different from per se illegal. So when the GFTC sees whether an agreement violates the AMA, they will see whether there is substantially restricts competition or not. And here, so if there are information exchange and some correspondent conduct, that will be agreement when substantial restraint of competition is found. So when looking at whether substantial restraint of competition is found or not, the situation of COVID-19 can be considered. And next, I would like to introduce some JFTC's press releases and Q&As with regard to COVID-19. By the way, in Japan, state of emergency was declared on April 7th until May 6th, but that was extended to May 25th. So the state of emergency was declared during April 7th to May 25th. And during, before that, on February 27th, the JFTC issued a press release and explaining that the JFTC requested Related Business Trade Association disseminating members not to conduct tying sales of masks or any other hygiene goods under the situation where the supply of masks or such hygiene goods is insufficient and there is no substitute for masks. And probably that happened around the world. We are lack of masks. Before that, we had plenty, but suddenly we couldn't buy masks, or that could be a very unreasonably high price. So the JFTC issued that press release and also requested that. And next is on March 10th, the JFTC, along with other ministries, requested businesses via related associations to give appropriate consideration to transactions with self-employees and freelancers affected by COVID-19. So self-employees and freelancers are easily directly affected by COVID-19. So counterparties shall be careful or should consider to not to treat unreasonably with them. And then on April 1st, the Secretary General of the JFTC briefed about the JFTC's efforts related to COVID-19 and also mentioned that collection of hypothetical measures in the event of an earthquake or other emergency would be referable for the COVID-19 situation as well. As many of you know, we had a big earthquake on March 11, 2011, and the year after, the JFTC issued the collection of those cases. And on April 23rd, the JFTC issued a Q&A whether instructing retailers by a manufacturer to sell certain products such as masks at certain price or less violates the AMA as resale price maintenance. And the JFTC's answer is there would be a justifiable reason for such conduct considering the current situation, because the purpose of this is not to have retailers to set unreasonably high price for masks, and that if such conduct is limited for a certain time period, that should be justifiable. Generally speaking, resale price maintenance, even for setting maximum price, was understood to be resale price maintenance in the past. And I think this is the first time for the JFTC to clearly express about setting the maximum price would be justifiable resale price maintenance. Of course, it's not always justifiable, but for certain situation, that would be justifiable. And on April 28th, the JFTC compiled relevant materials into one place regarding the JFTC's response to the efforts of business with regard to COVID-19, including collaboration between competitors for supplying materials smoothly, measures taken by manufacturers to deal with companies that sent unreasonably high prices, dealing with small and medium subcontractors, and conduct that harms consumers' interests. And finally, on May 13th, the JFTC published Q&As regarding transaction with small and medium subcontractors under the Subcontract Act, which also mentions about possibility of abuse of fair bargaining position. So I'm covering the next topic about business collaboration. So should permissible collaboration be subject to prior enforcer approval, or is that impractical given the challenges of lockdowns and COVID-19? And before providing my views, here is a basic rule for business combination control framework in Japan. If companies plan to collaborate, if that falls in share acquisition, merger, splits, joint transfers, and business transfers, then it would be subject to pre-notification when the turnover threshold meets. And if not, it's not subject to pre-notification. But in either event, the JFTC will see whether collaboration has substantially restricted competition in any market, any particular field of trade. And again, the JFTC will see or can consider the situation of COVID-19 when considering whether it has substantially restricted competition or not. And next, here's abuse of fair bargaining position regulation. And the reason I added this slide here is because abuse of fair bargaining position is one of the tools the JFTC can use. And also people think that it was told that ASBP is unique to Japanese regulation, but it looks like other jurisdictions are also introducing recently. And when I was asked about this to be this panelist, I have been thinking, what is competition law and COVID-19 in Japan? And I still don't know. I still don't have a clear answer, and that's because we are still living with COVID-19. COVID-19 has not been over yet, but I have to give some takeaway at some point. So I was chatting with the former Secretary General of the JFTC, Mr. Nakajima, who is a special advisor to White and Case right now. And his view, of course, he's not a JFTC officer any longer, but as a former enforcer, his view is that the JFTC will be using ASBP when they found any violation conduct. This is unilateral conduct, by the way. And because when going back to, for example, on May 13th Q&A, the JFTC mentions about subcontractor and ASBP, and that's one of the signs that the JFTC may be considering to use that tool. And by the way, I forgot to mention, but during the state of emergency, we don't think the JFTC conducted a downward as long as publicly available information. But according to newspaper, the JFTC conducted downwards on September 9th, and also for different case on September 30. So the JFTC is becoming active again, I think. That's it for me. Thank you.
Thank you, Takako. And also thank you for sharing with us what I believe were some comments in anticipation of how JFTC might view relevant conduct in Japan. So I think that was quite insightful. So what I'd like to do now is to invite Dr. Corinne Chu to give us the Singapore perspective. And I understand you have some slides as well to share. So over to you, Corinne. Thanks.
Thank you, Anand. I shall share my slides. Thank you. I'll just skip ahead. So Singapore's COVID-19 response measures include economic support measures, and amongst others also the implementation of the COVID-19 Temporary Measures Act, which provides for temporary relief to businesses and individuals who are unable to fulfill their contractual obligations because of the COVID-19 situation. The Act was passed in consideration of the impact of the COVID-19 situation, including the safe distancing measures applied on contracts relating to commercial undertakings, for example, construction projects which had to halt during the circuit breaker, and commercial and industrial tenancies and individual consumer transactions, for example, bookings for events or weddings. So the Act complements the financial measures announced in the resilience budget and provides temporary and targeted protection for businesses and individuals who are unable to fulfill certain contractual obligations because of the pandemic. But with regard to the application of competition laws in particular, along with the other regulators such as the UK Competition Markets Authority, and I think Anand mentioned them just now, the Competition and Consumer Commission of Singapore issued a guidance note on collaborations between competitors in relation to, in particular, supply of essential goods and services in Singapore. So the guidance note was, let me skip ahead to it. The guidance note was issued in recognition that the disruption arising from the COVID-19 pandemic may require companies to temporarily collaborate to sustain or improve the supply of essential goods or services. And so for a temporary period only, the CCCS will assume that collaborations that sustain or improve the supply of essential goods or services in Singapore, which are limited in scope and time, and which do not involve price fixing, bid rigging, market sharing, or output limitation, are likely to generate net economic benefits, or NEB, which is what Dr. Ian Mcewen was speaking to just now, and therefore are unlikely to infringe the Competition Act. So this is really an assumption of net economic benefit rather than an allowance of this collaboration between competitors. And this comes with a promise that the CCCS will generally not investigate such collaborations. I think the assumption here, though, is very limited in scope, and this is where I need to caveat. It's limited in time. So the guidance note applies to such collaborations put in place from 1st February 2020 and which will expire by 31st July 2021. And the type of collaboration, as I mentioned just now, price fixing, bid rigging, and the more egregious type of collusion is not allowed, is not permitted. And importantly, it's limited to the list of essential goods and services which is maintained by the Ministry of Trade and Industry on their website. If anybody's interested, this is at covidgobusiness.gov.sg until 1st June 2020. So this is a very specific list, and examples of essential goods, for example, are health and social services, including hospitals, primary care services, community care services, supporting services, and essential supply chains. So these are very specific services that the guidance note applies to. And an example of a collaboration that, for example, can fall under the COVID-19 guidance note provided by the CCCS would be where businesses agree to share production lines or inputs to increase total production of testing kits or its components for the purposes of addressing the COVID-19 pandemic. So the CCCS has issued this guidance note, which only applies in very limited circumstances. And as Anand mentioned also, the CCCS, similar to other regulators, has actually been quick to point out that it would not condone situations in which businesses take advantage of the COVID-19 pandemic to engage in anti-competitive conduct or use the pandemic as a Trojan horse, so to speak. Anand mentioned the ASEAN Expert Groups on Competition, which is a forum for Southeast Asia's antitrust regulators, and their joint statement, which basically, like Anand mentioned, warned that it would not hesitate to take action through national competition authorities in each member state against businesses taking advantage of the COVID-19 pandemic to engage in anti-competitive conduct. So one of the issues that Dr. Ian Mcewen mentioned just now that has been debated in the global fora is whether the failing firm defense tests in merger regulation will be reassessed in light of the impact to the sustainability of businesses and changing demands and business strategies with the COVID-19 situation. For example, what has been debated is whether a flailing firm rather than a failing firm defense will be available. So to my knowledge, the CCCS has not announced anything, any change to its assessment of distressed acquisitions. And indeed, many other authorities, from what I understand, have actually said that they will continue to apply the stringent failing firm tests. Another question for merger control in the COVID-19 situation is actually whether economic policy would override merger regulation regimes. And we see this in the Philippines, for example, as part of its response to the pandemic. There is this, I don't want to mispronounce this, but I think it's the Bayanihan to Recover as One Act. It exempts compulsory notification of those mergers and acquisitions with transaction value of less than 50 billion pesos, which are entered into within 2 years from the effectiveness of the Act. And the Act also suspends the Philippines Competition Commission's exercise of motu proprio review of these mergers and acquisitions for a period of 1 year. But interestingly, the PCC, the Philippine Competition Commission, has actually issued merger review rules to be followed over the next 2 years in light of the Bayanihan. And the rules also clarify that all deals entered into during this period may still be reviewed by the PCC after September 15, 2021, which is when it expires, and when it regains its motu proprio powers. So the PCC also emphasized that companies may still choose to voluntarily notify and be subject to review periods of 45 days for phase 1 and 90 days for phase 2. I think there's this tension between policy here and merger regulation. And what happens is that this essentially simply renders a suspension of notification requirements, but in effect, such mergers may still face regulatory scrutiny and enforcement eventually. Notwithstanding, and as a practitioner, not in terms of what money that I can get, but more in terms of what I believe in, as also a practitioner that advises regulatory bodies, I think that it's important for competition authorities to take stock of the possible changes to the economy and markets arising from the impact of the pandemic and the need for investment to support temporarily failing structures or to help businesses diversify and recalibrate. We had always had to consider for Singapore, Singapore's small economy and consumer base, as well as its policy of being the gateway to the ASEAN market. And this needs to continue, but also against the backdrop of the impact of COVID-19 and possible shifts in business sustainability and also strategies. As an example of the impact on business, which is something that has been debated in Singapore for the past few weeks, increased failure and unemployment has led to protectionism in the population and a call for Singaporean jobs to be preserved over foreign labor. This has also led to calls to stop foreign labor creation, which in turn has led to concern by foreign MNCs operating in Singapore. Our Minister, Chan Chun Sing, has reassured foreign companies operating in Singapore that Singapore remains open and welcoming to foreign MNCs as well as their labor, notwithstanding the pandemic and the job losses in the Singapore population. I would end here and I'll take questions later.
Thank you, Corinne. And thank you also for sharing with us some of what you found in relation to what the PCC has issued. I think that's quite interesting. And it's very relevant given the regional flavor of our panel today. So thanks for that. So with that, I'd like to invite Dr. Tuan from Vietnam to give us an overview and some comments on this issue from his perspective.
Thank you, Anand. Please let me know if you cannot see my slide.
Sure. And after you, Dr. Tuan, we will call upon Leah. Thank you.
Okay. So you can see my slide, right? Thank you for having me in this webinar. In my 5 minutes talk, I will try to cover the Vietnamese law, competition law perspective. In my opinion, there are three critical issues that may relate competition law to the COVID-19 is state aids, cartels, and merger control. So just to give the audience a bit of understanding of the Vietnamese competition law regimes, I would like to introduce you briefly about what the law is about. Basically Vietnamese competition law does not provide any statement on what is the objective of the law, but looking at Article 6 of the law, which prescribing about the competition law policy, it is arguable that competition law in Vietnam is to prioritize competition process or to protect competitor over consumer welfare. So the list of order of priorities, competition process first and consumer welfare come later. State aids are not officially recognized in the law. This is a big step forward, given that the state have the tendency to interfere in business conduct in reality. Horizontal and vertical cartels are generally prohibited with a few exemptions. And exchange of information that lead to formations of anti-competitive agreement is also prohibited under Article 8 of the law. So this is quite similar to what Takako has already explained. Regarding to merger control, I must say that the new merger control regimes in Vietnam is quite excessive, given that filing firms' defense are not available. And also intra-group restructuring is not exempted from the merger review. And the notification thresholds are very low. For example, like any merger transaction with the transactional value from 50 million US dollar would be notifiable. Or if the combined the total assets or turnover of the parties is from 150 million US dollar or above, and also notifiable. So this is very low thresholds, and so most of the transaction that we are working on are subject to merger review, and that result in the overloaded work in the competition agencies, and also prolong the practically prolong the merger review process. So the question is, have adverse socio-economic conditions brought by the pandemic affected the application of competition rules in Vietnam? The answer is not so much. Today, there's a subjective and objective reason for that. Today, no exemption to antitrust rules has been issued, even if the state already applies certain relief package, cover financial supports, in terms of tariff, in terms of capital injection for the SMEs. But from a competition law perspective, we still don't have a national competition commissions, which is the competition watchdog under the new competition law. So the current quasi enforcement body in Vietnam at the moment is the VCCA, Vietnam Competition and Consumer Protection Authorities, is taking charge of competition enforcement. But it is arguable that the VCCA does not have the legal standing to handle competition investigations and sanctions. So, and also we still don't have a guideline for leniency program or cartel regulation in the pipeline. We are expecting to have the NCC to be established by the end of this year, and the guidance for leniency program at the same timeline. Until then, the enforcement is not certain. By observing what happened in Vietnam, in my opinions, the competition authorities and the perceptions of the state agency about competition violations, particularly against cartels, are quite relaxed. From the very first law, which has to be which enacted 15 years ago, only 2 cartels investigated and fined, and most of cartels detected just received warnings. And during the COVID-19 situation, the administrative measures appear to be more effective and timely than competition procedures. For example, there was a cartel amongst the importer and distributors of face masks and sanitizer liquids. And in that case, the state agency interfering in issue sanctions against the involving parties, and because of that, the competition authorities, they don't have the authority to investigate and sanction those cartels. But the public's perception is quite happy with what the government has done in that case, because it's have stabilized the price of essential products at that time, which is a face mask and sanitizer liquids. And state-sanctioned cartels and mergers bypass competition rules in name of industrial policy. So I'm glad that Dr. Connie also mentioned about that whether economic policy will prevail competition policy, because in Vietnam apparently it is the case. So we hope in the past petroleum retail cartels, mergers among telecommunication firms or banking institutions are sanctioned by the state agency without referring to the competition authorities. So the next slide, because our colleagues here has already mentioned about the measures that have been implemented in other countries like Singapore, UK, or the US. I don't mention it here. From what we learned in Vietnam is that developing countries like Vietnam are always under pressures of maintaining economic growth. So the growth rate is a crucial parameter for evaluating the efficiency of the government each election period time. So the commission government agencies are very cautious about maintaining a high economic growth, and during the recession, that indicators have been seriously impacted, and it creates a lot of pressures against the government. From that perspective, perhaps recession cartels in Japan in 1970s or the measures adopted by neighbor countries might be good reference for policymakers in Vietnam to resolve short-term solutions. In terms of crisis, commission law should not rigidly penalize on businesses for coordinating or collaborating their effort, which is, I think this is also seen to suggested by in other countries. The suggested approach adopted by the other countries, like in Singapore, that like most of the countries are select to partially enforce the law instead of reduce the fine or stop enforcing the law at all. And also a balanced and proportionate approach is recommended to, on the one hand, allow businesses, and particularly the small and medium enterprises and vulnerable businesses, to survive the hardships of the COVID-19. And on the other hand, the commission agency should able to prevent and penalize those attempt to capitalize on adverse conditions to exploit consumers and enrich themselves, like the face masks and hand sanitizer cartels. So in some specific suggestions from my understanding is exemption to commission law during the crisis should be granted conditionally, which means that not all collaborative activities are permitted, like in Singapore. Hardcore cartels are still not included in the exemptions, and the exemption only granted temporarily, which means after the hardship is over, the commission law should be fully enforced again. The second suggestion would be the commission agency should expedite the process to promptly address the request for exemptions or even the merger review. So from our experience when we're working with merger clearance recently, is that due to the workload of the commission agency, the reviews are taking longer than is need to be. So it will create more. It will result in more difficulties for the relevant parties, particularly if there's a parties that is in the edge of bankruptcy. Everything needs to be done very quickly, and the solution needs to be resolved. It needs to be implemented immediately. And for Vietnam, perhaps the commission agency should relax, should be more relaxed on merger control. Suggests to higher the notification thresholds, or just exempt the intra-group restructuring, or just allow filing firm defense. That would create more leeway for the party to recover from the damages caused by the pandemic. But of course, the relaxation of merger control should be limited to the extent that it should not cause a systemic risk in future, such as shortage of supply due to lockdown. For example, like I learned that in the US, there's a meat packing case where the US Commission authorities, they allow merger among the meat packing cages, meat packing manufacturers. That's result in only 5 or 6 meat packing manufacturers competing in the market, but 1 or 2 of them was locked down, and then it immediately caused a lack of supply of meat to the consumer. So the number of the competitor in the market should be also be considered, like Dr. Ian said, suggests. Perhaps the merger control should consider to the look into also the existing number of the market players. And the last is Commission watchdogs should that exam or relax antitrust rules should retain the discretion to launch investigation into any effort to capitalize on or otherwise take advantage of pandemic to cover any anti-competitive practices. Taking example from Vietnam is that, you know, when there's a price fixing cartels among the face mask distributor, and then the Commission agency, they didn't do anything, but all the administrative agency, they interfere in and stop the misconduct. This is also a damage to the reputation of the Commission agency among the business community. But if they do it more proactively and efficiently, and then it can be a good chance for them to gain the reputations among the business communities, and also enhance the awareness about the Commission law and policies in Vietnam. So this is my end of my presentation. So I would take question later. Thank you.
Thank you very much, Tuan. And with that, I'd like to invite Leah to give us, to share with us her observations of the Indonesian perspective.
Thank you, Anand. Okay. From Indonesian perspective here, I would like to share some key issues with regard to the KPPU recent action during the COVID-19 pandemic in Indonesia. Regardless of the COVID-19 pandemic in Indonesia, it seems that KPPU is still enforcing some Indonesian anti-competition law actively. I would like to raise some at least four major issues that being monitored by the KPPU. First, with regard to the COVID-19 rapid test services. In this regard, that I think some publics or people already made a complaint to the government with regard to the higher price for receiving or taking the COVID-19 rapid test services provided by hospitals. So in that matter, that KPPU has to make sure that the hospital will provide a reasonable price for the public to use the COVID-19 rapid test services. So I think in the beginning of this COVID-19 rapid test services introduced, the price would be around 100 USD up to 200 USD. And just recently, government determined that the rapid test service provided by the hospital should be reduced up to 900,000 rupiah. It's around like maybe 60 USD to enable or to cover all the society all the level of publics to use the COVID-19 rapid test services. The second issue is with regard to the appointment of the Indonesian partner for implementing a pre-work card program. This is part of the Indonesian government effort to assist or to help the unemployed citizen. So in this program, the government invited some business player and to give like a proposal, and then the government will evaluate the value and also the ability of this business player to work together with the government to implement a pre-work card program. However, from the KPU perspective, this kind of the program could lead or potentially lead to the competition, the unfairness amongst the business player, and because apparently only maybe major business player which can afford to give or to afford from the financial perspective to give or to provide the facilities are needed by the government. Looking at this context, it seems that because there are two major marketplaces which interested in submitting this proposal. So like Bukalapak and Tokopedia, they have so finally they have consulted this matter with KPPU. So just to make sure that they will not violate the anti-competition law. And finally, what we understand from the KPPU decision on this pre-work card program seems that the KPPU believe that this is permissible, because eventually I think the KPPU will see the final impact for the Indonesian citizens. The third sector that being monitored by KPPU is with regard to the reasonably high gasoline retail price in the domestic market amid a drop in the global oil price. The last sector that I would like to address is with regard to staple food product price trends. So KPPU has asked for market information from more than 270 business actors. The key case that lead or that trigger the KPPU to start investigation is with regard to the garlic importation. So in this case, KPPU saw that there is a potential cartel amongst the key business players, and the KPPU would like to make sure that the importation will be conducted properly, and to make sure that the business players will fulfill the obligation under the importation license, and there will be no lack of supply and demand on the garlic demand in the market. So there's some also attention from the KPPU, especially with regard to the tender process. So like the pre-card program. So the KPPU also monitor and try to manage the procurement for the hospital, not only the COVID test service, but also for face mask, hand sanitizer, like the medical equipment. So this is also one of the key sector that being attention by the KPPU. Of course that even though there is no clear guidelines on how the KPPU will react or will respond to this kind of trend, for example, because of the lack of supply and demand, and then how the KPPU will give some relaxation or temporary exemption, still I think KPPU only issue like unwritten policy, so they may see or evaluate the issue on case-by-case basis. So there will be no clear guidelines on how the KPPU will provide the temporary exemption or relaxation here to the business player. So I try to respond to each question raised by LAWASIA here for this session. So the first question is that, is it acceptable for competitors to exchange information during pandemic? And if so, to what extent? So far as we know, there is no, there is still prohibition issued by KP or the law that there is a prohibition for exchange of information. So there is, the standard rules still apply. So there is no relaxation in this issue. So still that business actors are prohibited from colluding or to obtain secret trade information from the other competitors. So it is strong recommended that sharing sensitive non-public information, it should be avoided. So it's because in some cases, in some cartel cases, like meeting amongst the business business players in the association, that will be used as a preliminary evidence for by the KPPU to start investigation to see whether there is indication of a cartel. The second question is, does permissible collaboration require prior enforcer approval, or is it not practical given the challenges of lockdowns and COVID-19? Well, still similar to my first answer is the no collaboration without approval is being permitted. So in this issue, I think KPPU is still adopt a stricter approach. So, and in the normal market condition, and even now during the COVID-19 pandemic, collaboration among competitors, which may lead to anti-competition monopoly practice, is not allowed. So, well, the thing that maybe could be allowed by the KPPU is with regard to the partnership amongst the large-scale business player with the medium or small size business player. So we call it not collaboration here, but we call it partnership. So there are some type of the partnership which basically which will basically enable this business player to work together, and hopefully that the large business player will help the medium and a small size business player to expand their business, and to also to expand their business, and to make a progress from the not only from the business perspective but also for the financial perspective. And the third question is, has COVID-19 changed the landscape for dominant undertakings, and if so, to what extent? Not as far as we know. So the dominant provision is still applicable. So under the Indonesian competition law, one business actor or group has a 50 or more market share, or 2 or 3 business actors or groups have a 75 or more market share. So that's that's the measure decided in the law. So for the business actor possess market by other means, regardless of so the business actors possess market power by other means, so including the absence of meaningful competitor, regardless of any particular market share. Should competition law be automatically suspended during a pandemic, or is it practical to have a regulated system of exemption? Well, I think from the practitioner perspective, practitioner view, temporary exemption are the best approach at the moment. So, and we also note that in addition to giving temporary, what you call it, temporary exemption, like I already advised before, even though it is based on the unwritten policy, KPP also applied the merger control policy during the COVID-19 pandemic. So in March and April 2020, KPPU temporarily suspended merger control notification. So the due dates can be delayed or postponed just to give more time to the parties to prepare all the documents and submit the notification to the KPPU. And during this pandemic also, that KPPU also applies work from home. So they also issue policy with regarding how they implement the work, how they enforce the investigation and so on during the pandemic. So basically what they say in the policy is that they will implement online system. Of course, that unlike in the conventional approach, there are some of course glitches, some obstacle in dealing with KPPU during this pandemic, especially because we cannot meet them, we cannot have any consultation with the KPPU. So our communication is through email, and sometimes we have to make a call to them to make sure that we have for example, to make sure that we comply with the deadline, we comply and we can fulfill their requests with regard to outstanding.
Yeah, sorry to interrupt. Just a quick reminder on timing because it's coming up to Andy's slot now, and also for Ian to say a few quick words at the end.
Okay. Yeah. Thank you.
Thank you.
Yeah,
Thank
I
you.
think.
Sorry for that.
Yeah, no problem. I think the second is the cash handling method. So again, the KPPU aims to maximize the use of electronic media, and even though for the investigation they still conduct manually, so they still visited the area, or they still open for meeting to have like interview and so on. So that's something that I think for the investigation, KPPU is still doing it manually. Again, this is direct appointments. So it seems that the KPPU also give a relaxation or a sanction for direct appointment for the procurement of goods, especially in the health sector. And I think my last comments is with regard to suggestion from the lawyer, from the practitioner. So I think it's similar to the other speakers. So basically what we suggest to the KPPU is that to provide a waiver, for example, like merger filing requirement, especially for the transaction involve small and medium business sectors. Then it will help them in preparing documents, and especially who do not have a very healthy cash flow. So I think they should be given more relaxation in terms of anti-competition. So I think that's all my presentation, Anand. Thank you.
Thank you, Leah. And with that, I'll invite Andy to give us his perspective from New Zealand.
Okay, thank you, Anand, and I will take the hint and keep this quick. There were really three things I wanted to cover today, and everyone's covered the points really well, and it's been very interesting, and thanks everyone for including me. I think for me, overall, we're talking about timing issues, short run, medium run, long run. We're talking about broader economic impacts versus particular industries that are flying through, whereas other industries are hit hard. And we're talking about, are we taking a legal approach or a pragmatic approach, or neither on these issues? The first point I wanted to say is, in relation to New Zealand, we have very strict, very broad per se cartel prohibitions. Now, a lot of other jurisdictions have those, and it's been touched on well by the other speakers. And that, to me, is one of the main areas to be thinking about here, and picked up very well, particularly in Vietnam, where concerns were mentioned about that. And for me, the overarching thing is we also have a resale price maintenance prohibition, but there are many of the other areas are arguable on a rule of reason basis, and short-term sort of necessary things will be okay. But when you've got a per se prohibition and you have very broad overarching capture and potentially narrow exceptions, that's where the rubber hits the road, and it creates uncertainty for business. So against that backdrop, I just wanted to talk briefly about the New Zealand experience, and I will go through this quickly. Our timing, we had a hard lockdown. We're lucky, we're remote, we're small, we shut the border. We moved very quickly from a system in late March where we had an alert level system, and our relevant minister basically sent a statutory notice to the Commerce Commission saying, please be pragmatic. The Commerce Commission on the same day said, yes, we will be. We don't intend to take enforcement action against businesses cooperating and really dealing with essential services during this unprecedented time. And that's obviously the other point. This isn't like normal recessions where we know how to judge things, engage things, and there was obviously tremendous uncertainty at the time. On looking at this again and seeing the timing of similar announcements in the EU and UK, you can see that the regulators have been coordinating well. So ICN and other initiatives have done their work here because the timing was very, very similar. So we had what was called a government policy statement, which by law the Commerce Commission needs to have regard to, but then in the past has traditionally quite often gone on and then made its own independent decision as an independent body. But here in New Zealand, we've seen a high level of pragmatism. And then by May, the Commission published business collaboration guidelines. Now, they don't say much more than common sense, really. If it's necessary and it's short term and it doesn't do harm, it'll be okay. And we're not going to be aggressive about this. What is interesting is then very shortly after that, touching on a point that Ian raised, is we had some emergency legislation passed, and this deals with our authorisation, which is much as Ian outlined. And what it does enable is it enables parties to apply for an authorisation on the basis that public benefits, which is the broad test here, so it's not just economic efficiencies, exceed the anti-competitive detriments. And the Commerce Commission can basically say to people, you get started, you've got a provisional authorisation, and they can dispense with some of the formalities around draft determinations and conferences. So that's really shown a lot of pragmatism, and the Commission's given guidelines then to match that. I mean, again, arguably the substantive law hasn't changed, but the procedure and the concern that there might have otherwise been about the bite of excessively broad per se prohibitions has kicked in. So what don't we have? We don't have, we've had a lot of consumer law issues. The Commerce Commission has really been pretty quiet, even on other investigations. They've been slowed down by COVID. We don't have anything around price gouging, unlike some of the other jurisdictions. So my last slide, I just really wanted to sort of pick where do we think the issues will be or what are the predictions. I think like past recessions, there'll be a wave of mergers with all the issues that we normally work through, but we're probably going to see, like we normally do in recessions, we are going to be seeing cartels starting up. So down the track, there'll be some more business. I think the mergers will come quicker and sooner. And I think you'll see more infrastructure sharing because I think at a macroeconomic level, you're going to have slowdown for a bit. Anyway, I'll pass over now, Anand, because I know we're short of time.
Thanks for that, Andy. I think we just have enough time, Ian, for a few quick words. I understand that you have to leave at 4. I'm happy to, I actually don't see very many questions coming into the Q&A. But I'm happy to, if the organizers are okay, I'm happy to just take an extra 5 minutes to deal with questions quickly, if there are any. But Ian, over to you.
Yeah, well, look, I'm sorry I have to go. Look, one of the things that really I noticed from the different presentations, which I'm very pleased to listen to, is how different the laws are in dealing with these sorts of situations. Australia and New Zealand, I think, have probably the best, one of the most flexible arrangements in the world, even perhaps more so than the United States, which surprised me. And I'm a little bit surprised that there hasn't been a little bit more agitation from lawyers within Asia, including within ASEAN, for more guidelines from competition agencies. I know that Taiwan hasn't put anything out, but they haven't put out guidelines on quite a few other things that they should have put out by now. I can say that because I'm not there at the moment. But I mean, I think as this is a Law Asia seminar, I think it's worth pointing out that lawyers have an interest and a public interest in ensuring that rules are, suit the occasion. You shouldn't have to go along separately over which could be years. The consequences for this could go on for several years. If a merger is stopped when there's various legal remedies, which could take 2 or 3 years for the courts, and a whole range of other sorts of conduct as a result of perhaps collaboration in the short term, which isn't picked up by the competition regulator, but perhaps picked up in 2 or 3 years. I mean, the competition regulator should be providing more guidance, I think. Yeah, I agree with Andrew about this per se problem. I've been involved in a recent case where per se has really been, interpreted literally by a competition regulator and ended up with what I would think is a silly result. And there's just far too much of that within Asia, including ASEAN. You've only got to look at the market share thresholds that were used in several countries in ASEAN for mergers. They just didn't make economic sense, and I'm just hoping that this might provide a bit of a catalyst for a reconsideration of the economics underpinning it. I know I'm going back to the economics. I'm still a lawyer, but the reason I did law was when I looked at legal issues, because my other areas have been intellectual property and corporate law, I noticed that there wasn't a lot of economic justification for them. Perhaps initially, but over time they changed as circumstances change. So I think, this, as I said, just to finish up, that law associations, including LAWASIA, should perhaps doing a little bit more on that. I know the ICN does, but that's the audience there are regulators. I think you need to get the public a little bit more aware, and policymakers a little bit more aware of what's really the problems that are likely to arise as a result of COVID, which I think are going to be still quite considerable. I'm a bit too old to take advantage of it in 5 or 10 years' time, but you guys are all young enough that you may be able to. Okay, well, sorry, that's all I can really comment on, given the differences. So thanks very much, I appreciate it, and good luck.
Thanks, Ian. Thanks for joining us. We'll just carry on for a few minutes that we have. So a quick check with Shanna and Magda. I don't see any questions in the Q&A. I don't see any questions in the chat box either. I'm happy to just maybe talk through the next few minutes with the panelists. I'm not sure if we should just end at 4 sharp, or if, given the absence of questions, perhaps that's what we could do. And we won't have to keep anybody waiting. So unless you interrupt me with a different instruction, that's probably the direction we're going to go. So I would just add to Ian's comments to wrap up, and that is we can see from what the panelists have covered quite extensively, both in their jurisdictions and perhaps some have also looked at neighboring jurisdictions, that there's a varying degree of sophistication with which the competition authorities have dealt with COVID. Some have come out quite quickly. And it's not just the fact that you make a statement. I mean, you really do have to make a statement in a timely manner. And I think in Europe, we've got a lot of guidance up front. And we've seen the ECN, for example, saying that they will not actively intervene when there are cases of shortages, scarce materials, scarce goods, and, with the sensible things. I mean, they've put out a set of guidance and guidelines, rather. And, the GCR did an interesting survey and it found in terms of collaboration, some people were happy in some jurisdictions. They were prepared to go out and enter into collaboration on the strength of legal advice alone and without having to go to the regulators, because in those jurisdictions, perhaps, the regulators may have issued sufficient guidelines that it was enough to get legal advice. And another comment was they didn't have time to go to the regulators because some things were just happening too quickly. So in the UK, for example, there's this program where there's some acknowledgement that competitors, especially among supermarkets, do have to collaborate to ensure that there's enough supplies, that stocks are available in all parts of the country so that the nation can be fed and essential goods are available during lockdown. So there's a fair bit of acknowledgement and upfront guidance given by authorities, and that's what people are looking for. And the absence of such guidance is worrying and would sometimes perhaps lead to the concern that those authorities who are not issuing guidance may not be prepared to deal with and analyze competition law concerns and issues that arise during the pandemic. So that is an area of concern. We do hope that these things will clear up as we go forward. So I see that we still do not have any questions. And I guess then that we hope that this event has been useful for participants and that you've obtained an insight into the various jurisdictions covered. And in case your jurisdiction is one of those, like us in Malaysia, where there is no specific guidance issued by the authority, you'll be able to get some thoughts from how other countries are dealing with it to help in your analysis. If you're a lawyer, in your analysis of the issues and your advice to clients, or if you're an enterprise or undertaking, to help you chart a way forward. And with that, it remains for me to say thank you very much to our distinguished panel of speakers. Thank you so much. And stay safe, everyone. And there are some messages in the chat box and in relation to becoming a member of LAWASIA, if that is something that you're looking forward to or you're keen on, please do check out the chat box later on. Thank you once again, Magda and Shanna, for putting this together. And thank you for the panelists for volunteering your time and expertise. Thank you once again.
Thank you.
Goodbye.
Thank you, Anand.
Bye. Thanks, everyone. Bye.
Thanks, Anand. Thanks, everyone.
Thank you, Anand. Thank you, everyone.